You've been sued by your landlord and you just wish the case would go away, so you had the time and the money to move, which you were planning on doing anyway. You just need a break. This is the desire I hear tenants state all the time. Therefore, in this episode of Learn to Live Better, we look at a housing court hack that might give you the time and the space that you need. New York City tenants have more rights than tenants anywhere else in America. But New York City tenants are also shockingly uneducated about what those rights are. A right you don't know you have is the same as no right at all, and there are so many bits of incomplete information out there. This podcast will change all that. In each episode, we look at current legal cases and statutes and the real-life apartment stories they give rise to here in the greatest city on earth. And every episode ends with a tenant takeaway, so you have actionable information to help you make better choices. The law belongs to you, New York City, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I'm Michelle Itkowitz, and this is Learn to Live Better, a housing law podcast. This is a housing court hack episode of Learn to Live Better. If you look at my back catalog on the Tenant Law podcast feed, I have 6 other episodes like this, housing court hacks. A housing court hack is where I tell you about a technical defense in housing court that a lot of tenants could be using, but that you wouldn't know about if you didn't have a lawyer. A housing court hack is not a way to substantively win your case and make it go away forever. Rather, a housing court hack is a way to possibly get the current case against you dismissed because your landlord's lawyer did something procedurally wrong. This can possibly give you the space and the time you need to negotiate a better deal for yourself. But first, as always, let's start by setting the stage with some context. Okay, so first we're going to start by talking about some background, some context you need to understand today's case. When your landlord sues you, they're suing you in the civil court of the city of New York, the housing parts of that court, so we call that housing court. And what's happening is the landlord is prosecuting against you a special type of lawsuit called a summary proceeding for the recovery of real property, otherwise known as an eviction case. Eviction cases are governed by a special law called the Real Property Actions and Proceedings Law. Real Property Actions and Proceedings Law, Section 741(3) says, every petition, the petition is the lawsuit papers, every petition shall describe the premises from which removal is sought. So, case law has expanded this, and our rule is this, that the petition, the lawsuit papers, must set forth the address and or the configuration of the premises sought to be recovered, your apartment, with sufficient precision to allow a marshal to execute on the warrant. Even if the description of the premises in the court papers, in the petition, reflects exactly the wording of how your apartment is described in your lease, even if they're exactly the same, that's still not good enough if what's there in the lease is itself confusing. In other words, the landlord's not getting off the hook if you say, hey, wait a minute, the description of my apartment is confusing. I don't know how anybody could find this apartment if they had to evict. If the landlord says, well, I followed exactly how your apartment is described in the lease, that's still not going to be good enough. It's not about matching the lease. No. It's about making it so if somebody was coming to evict, God forbid, they could find which apartment to evict from. Let me start to give you some real-world examples of how this gets confusing. So there's a case from 2022 called Ahmed versus Reed. Maybe I'll put a link to that in the show notes. In that case, the housing court dismissed an eviction case where the lease described the subject premises, the apartment, as the first floor. The lease says first floor. But the apartment was actually physically on the second floor of the building. Why? because the first floor in that particular building was described as the ground floor. The same apartment could potentially be called the first floor or the ground floor. In New York City, those are very interchangeable. Sometimes the first floor is the first floor, and sometimes the first floor is the ground floor. But that always leads to a little bit of confusion about what's above the ground floor. Is that the first floor or the second floor? But here's the thing. Sometimes if the first floor or ground floor is a little bit below grade, it could also be referred to as the basement. It becomes confusing when you don't just have something simple like an apartment number. When we're talking about first floor, ground floor, lower level, basement, second floor, it gets confusing, and this confusion can be used in your favor. Remember, the standard is that the marshal has to be able to figure out when they get there for the eviction which apartment is being referred to. If you were telling a friend how to get to your apartment and you weren't going to meet them at the front door of your building, would the description that's in the petition, in the court papers against you, if they followed that, would they be able to find where you are without calling you up on the cell phone and saying, okay, I'm here now, which door is yours? Is that the upper door? Is it the lower door? Wait, are you around back? Where's your apartment? Now, if you're in 7F and they press the elevator button and they go up to the 7th floor and there's 7A, 7B, 7C, and they find 7F, I mean, that they don't need your help with that. But they might need your help with first floor, ground floor, lower level, basement, front, rear, if it's not clear. So the standard is you look in the court papers, and if you were just reading those court papers, could you find the apartment? And if you can't, that is a potential defense. Okay, so that lays the groundwork we needed for today's case. So let's get into today's case. Today's case is called Osibodu versus Fahintola, and that comes to us from the New York City Civil Court Housing Part, so Housing Court in Kings County in Brooklyn. Brooklyn Housing Court, 2025. I will put a link to this case in the show notes. So let's talk about what happened in today's case. The tenant in today's case had a free legal services lawyer who said that the description of the apartment in the court papers was incorrect. They made a motion to have the case dismissed, but they lost the motion. The judge looked at it and said that she thought the description was adequate. But in the meantime, something very interesting happened. The landlord, maybe the landlord thought they were looking at losing the first case because the landlord got another lawyer and brought another case in the same court for the same reason against the same tenant. And the second lawyer in the second case described the same apartment in those court papers very differently than in the first case. The lawyer in the first case made another motion and said to the judge, "Judge, please reconsider our argument because we have some new information about this description of the apartment. We can show you it's improper because look how the landlord just proved our point for us. The landlord brought another case, same tenant, same apartment, but described the apartment very, very differently. So let's look at this. Here's how the apartment is described in the first case. One room, number 1, front apartment, first floor, on the first floor. But then along came the second case. Listen to how they described the apartment in the second case. Basement, ground floor, room A, front. I mean, it's different. Is this apartment on the first floor, like they say in the first case, or is it in the basement, which is what they say in the second case? Is this apartment number 1, like they say in the first case, or is this room A front, like they say in the second case? I don't know. Neither did the judge. So the judge said, I am going to allow you to renew your motion. And based on this new evidence, I am going to dismiss the case because based on this, I can't tell you where the apartment is, and I don't think the marshal will be able to either. So that's the case. There's stuff we really need to go over in the tenant takeaways. I've got 2 or 3 things for you that you really need to hear. Let's get the housekeeping out of the way first. Okay, this is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I'm asking you not to contact me. This podcast is not a commercial for me or my law firm. This is simply one of the podcasts that I always wanted to make. What I would like to hear from you on is what topics you'd like me to cover. My email is in the show notes. Now, this is the 6th time I'm dropping a Learn to Live Better episode in the Tenant Law Podcast feed. I guess what I've really done in essence is I've changed the name of Tenant Law Podcast to Learn to Live Better, a housing law podcast. This is probably not good branding, all this switching and putting Learn to Live Better in the Tenant Law Podcast feed, but whatever. My goal is not to be a brand. My goal is to get this important information to as many New York City tenants who need it as possible. So the show could be called Tenant Law Podcast or Learn to Live Better or Tea Time with Michelle. And as long as it helps as many people as possible, I don't really care. I'm never asking you for any money. There's no Patreon. There's no merch. I tell you in every episode, don't call me. This is not a commercial. But what you could do for me, however, if you're listening on the Tenant Law Podcast feed, which right now most of you still are, to help me help New York City's middle-class tenants is to go over to the Broadway Podcast Network and also subscribe to Learn to Live Better over there. Don't unsubscribe here from Tenant Law Podcast because I don't want to lose all the work I've done over here, but also subscribe over at Broadway Podcast Network, Learn to Live Better, and get our numbers up over there, which is obviously going to lead to the show being heard by more people. It is time for the tenant takeaway. Okay, tenant takeaway number 1 is that a possible way to get an eviction case in housing court dismissed is to question the accuracy of the description of the premises in the petition. And now I'm going to look at 2 contrasting examples. Okay, so example A. Let's say in the petition, in the court papers, the apartment is described as 7F as in Frank. And on the door of the apartment, it says prominently 7F as in Frank. And then the description of the premises in the lease says apartment 7F as in Frank. And then even on the mailbox for this particular apartment, 7F. It's 7F everywhere you look. This defense we're discussing today is probably not going to work for you. But let's look at another example. Okay, example B. Let's say in your petition, in the court papers, your apartment is described as rear apartment on the 2nd floor. Rear apartment on the 2nd floor. That's the description in the court papers. But the description of the apartment in your lease says apartment 2R. And on your mailbox, it says apartment 2. And on your apartment door, it says absolutely nothing. It's just an apartment door with no marking. You might get somewhere with questioning the description. I don't know if you're going to win, but you might get somewhere by raising it. That's the obvious takeaway. Tenant takeaway number 2. Now, there was something else going on in this case that I see a lot. Not a lot, but enough. And it's another possible defense. So remember what happened here. I'm just making an assumption that as this motion was being brought by the legal aid attorney, and it was a good motion, and it scared the landlord. So the landlord runs out, I guess, and gets another lawyer who files another case with a totally different description. Putting aside the description stuff, you can't file 2 lawsuits for the same thing against the tenant at the same time. It's a doctrine called, that we're not going to go into today. Maybe this is another episode, but I thought it was important to mention here today. Prior action pending defense. The prior action pending defense. You can't sue somebody twice for the same thing because, well, that's like judge shopping. Oh, I'll sue the person 3 times, and whoever the best judge that I like the best, or whichever case I think is going the best, I'll keep, and I'll get rid of the other 2. That's not how it works. You can't do that. And it's not fair. The tenant shouldn't have to be defending themselves in 2 places at once. That second lawsuit number 2, could have been easily dismissed by saying, hey, there's a prior action pending. Now, I don't know what's going to happen with the second lawsuit. I actually looked it up. It seems like it's just sitting there. Nothing's happened on it yet. Maybe they're negotiating, which is what we're going to get to next. But just keep in mind, you can't be sued twice at the same time for the same thing. And I see this kind of thing pop up enough. Okay, now the big takeaway. Tenant takeaway 3. Negotiation. I wanted to use this, our 6th housing court hack, to really drive a point home that I've made with respect to all the other housing court hacks. But I think each time I make it a little better. Okay, first you're getting an anecdote. So a guy called me for a free 15-minute consultation. He wasn't rent stabilized or good cause eviction law protected, so it was not a forever home apartment. He didn't hire me, but whatever I told him in those free 15 minutes, apparently it was useful, because when he called me a year later, he said, oh, thank you. Whatever you told me, I was able to get my case dismissed. Let me just say this about my free consultations. And again, this is not a commercial for me. I tell everybody in writing, in a paper that I send to them before I will consult with them, and I tell them when I'm consulting with them, that whatever you're getting out of a free consultation is not actionable legal advice, because it's not time enough to completely review your matter. So whatever. Thank God it worked out for the guy. But then here he is a year later, and he wants another consultation because there's another case. Now, I looked at it, and I didn't see the problem that had been there a year ago. Obviously, the landlord wasn't going to make the same mistake twice, and corrected it. And in this case, it wasn't like the case we looked at today. The first case was long gone. The landlord bought a second case, and it didn't bring it with the same problem that he did the first time. And I couldn't quickly see any other problems. There was just nothing obvious at that point. And the gentleman said to me, he goes, oh, I really just need this case to go away, because I just need a few more months of free rent, and then I can afford to move. I was planning on going anyway. I really wish I could negotiate, but I don't have anything this time like I had last time. Now, there is the problem. There's the problem. He should have made or tried to make a deal with the landlord when he had defeated the landlord on the first case. Now, listen carefully, because this is the important takeaway. The problem with the middle class not having access to lawyers, either because they don't qualify for legal aid because they make too much money, or they can't afford a qualified private counsel, either way, part of the problem is people wouldn't know the law. Who would know what I just told you today, that an improper description could get your case dismissed? That's like inside baseball. It's important, and it happens a lot, and it could probably protect a lot of people. Part of this podcast project is to educate you about the law, but it's more than that. And what you're getting here with me that you're not getting anywhere else is not just what is the information, but how do you utilize it? How do you best utilize it? So here's the thing. When the guy who called me got his first case against him dismissed, at that point, he had the maximum leverage he was ever going to have. At that point, he should have gone to the landlord and said, Ms. Landlord, I need 6 more free months of rent, and I'll be out of your hair. And you need to stop paying lawyers who lose cases in housing court. Let's both get what we need here. If you waive the rent that I owe and give me another free 6 months, I'll give you a judgment of possession and a warrant of eviction. That'll ensure you that I'll get out in 6 months. I don't know if you're going to get that deal, but trying to get that deal is what a good lawyer would do. That's what a good lawyer would put you into. Frankly, that's what a good lawyer for the landlord would do as well. I noticed that people, they have a fight with the landlord, they win, they do a victory lap, and then they sit there and wait for the next case. So let's do a little example here on the screen. Again, If you're not on the screen, just listen to my words. So what do you want? You want more time. You want your arrears waived. You want more free rent. You want a good letter of recommendation so you can go get the next apartment. And you want certainty of what's going to happen versus uncertainty. You don't want another case. Now, you don't settle a case by just thinking about what you want. You settle a case by thinking about what the other guy needs, because that's how you make a deal. So what does the landlord need? The landlord needs to stop paying lawyers to lose in housing court. The landlord needs to get the apartment back. This is the main thing they need. They need the unit back so they can collect rent again, so they can pay mortgage and taxes and salary. And the landlord also needs certainty versus uncertainty. And the holy grail for the landlord is a judgment of possession and a warrant of eviction, because that's the only thing that's going to get you out. And if you're willing to swap that for more time, waived arrears, more free rent, a good letter of recommendation, then that could be a deal that benefits both sides. So the takeaway is, if you use one of the housing court hacks I give you that we discuss here, and you use it to your advantage to get what you need by swapping with the landlord for what the landlord needs, that's where this should ideally go. If you had a good lawyer, that's what the good lawyer would be working for. Not just to keep you litigating and paying and keep the landlord litigating and paying. A good lawyer is going to bring about a mutually beneficial solution. Again, you got to think about what the landlord needs, and you have to think about what you need. That's key. You don't make a deal that is not a good deal for yourself. Don't make a deal that you can't keep to. So think about what you need, think about what they need, and have those conversations at your moment of maximum leverage. After you get a case dismissed on a procedural ground, don't just sit there and wait for the next case. Instead, use it, call up and just say, hey, look, what are we both doing? Let's stop with the court. Let's just make a deal that works for us both. Now, I don't know if it's going to work, but I'm just telling you that that's what the middle class is missing when they're not represented. And let's start to think about the material this way. There you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is Learn to Live Better, a housing law podcast.